Hi, my name is Cindy and today I'll be presenting. The first issue is what is the applicable law in determining the above said dispute. Arbitration is one of the alternative dispute resolutions to resolve a dispute between parties. It is a process where two or more parties who had entered into an arbitration agreement, which could be either incorporated in an agreement between the parties as a separate clause or it can be made as a separate contract. Basically, in this agreement, it will be illustrated that any dispute shall be resolved by arbitration method. In the case of Albert Resources Sendirian Berhad, it was held that by just having an arbitration agreement is insufficient to initiate an arbitration, but the most important thing is the intention to arbitrate. As in this case, both Bobo's family and Mr. and Mrs. Bobby Seale have agreed to undergo an arbitration. There shouldn't be a problem with this issue. The issue now is which law shall apply. Rule 1 of the AIAC rules is applicable in this case. Both parties shall follow the AIAC rules and AIAC shall administer the arbitration process as both parties have agreed to resolve their dispute via arbitration. Rule 7 of the AIAC arbitration rules is also applicable. We are also applying Section 30 Sub 2 of the Arbitration Act 2005. Under Article 35 of the UNICITRAL, the arbitral tribunal shall decide as amiable compositor. In the case of James Capel Far East Limited, it was held that where if parties did not expressly notify the choice of law to be applied, firstly, the court will find an implied choice by referring to certain matter like the clause in the contract or type of currency is used in the contract. Secondly, if there is no implied choice, then only the court will adapt the law based on circumstances like the place the contract was made and so on. In Thailand Lignite Co. Limited and another, the first appellant wanted to undertake a lignite mining activities in Laos and they had executed 2 mining contracts. Then the parties had carried out an arbitration agreement which was made in Malaysia. However, the parties did not specify which law is applicable to the arbitration. It was held by the court that if the parties did not expressly specify the law applicable for the arbitration agreement and there is a conflict of law, the court will apply the law which has close connection to the arbitration agreement. Since the arbitration agreement was made in Malaysia and the sitting of arbitration was in Kuala Lumpur, so the law applicable for the arbitration would be the Malaysian law. In the case of Government of India against Petrocon India, it was held that the sitting of the arbitration will determine the law applicable for the dispute. In conclusion, both the parties did not specify on which law shall be applied in the dispute. They only agreed to have the sitting of arbitration in Malaysia and utilize AIAC arbitration rules. So, the arbitral tribunal can take into consideration of the circumstance by applying Malaysian law to resolve the dispute. The second issue is, can the appointment of Mr. Benedict as an arbitrator be challenged? The short answer is yes, because he has a personal interest in the dispute. He is also a shareholder for Good Bread Berhad, which is the subsidiary of the McB group of companies that supplies burger bread to McB's franchises. In this case, it was held that bias is a predisposition to decide for or against one party without proper regard to the true merits of the dispute. Bias is defined as an attitude of mind that prevents the judge from making an objective determination of the issues that needs to be resolved. The test of biasness and breach of natural justice is provided in this Malaysian case, which is based on Halliburton Company appellant against Chubb Bermuda. In the UK case of Halliburton Company, the two issues were whether and to what extent an arbitrator is entitled to accept multiple appointments regarding on the same matter, where there is one common party in the claim, And the second issue is whether and to what extent the arbitrator could accept appointment without disclosing their previous involvement. There are two means to this test: duty of disclosure and rejection of challenge. It was held that the arbitrator holds the duty to disclose facts and circumstances which would give rise to the appearance of bias. However, the court took notice that as an organisation having an interest in the integrity and reputation of English-seated arbitration, it is best if the legal duty is furthered transparently. An arbitrator may have to disclose acceptance of appointments in multiple overlapping references with only one common party, depending upon the customs and practice of the type of arbitration in question. Thus, the failure to disclose overlaps where a common certainty may arise where there is biasness if this fails to adhere to. By applying to our current situation, Mr. Benedict, who is one of the panels of arbitrator, can be challenged as there is the possibility of biasness. Now the question is how to challenge. These are the applicable rules. In conclusion, Bobo solicitor did put forth an application to challenge the appointment of Mr. Benedict on 14 April 2022. However, on the same day, the director of McB Seal Incorporative had called the director of AIAC to inform him that they have yet to decide on the applicable law. The third issue is, had any one of the parties breached the trademark of the other party? If any, else which of the parties is the rightful owner of the trademark? In racket and common, there are three elements to establish passing off, namely reputation, misrepresentation, and damage to goodwill. The first element is reputation, where the plaintiff has sufficient goodwill, reputation, and presence in the trade name in question in the local jurisdiction. In the case of Dun and Bradstreet, it was held that reputation plus some market activity in the jurisdiction was sufficient to establish a business goodwill that was entitled to protection. The second element is misrepresentation. In Sid Chuan Seng against T Yi Jia, it was held that in order to create a valid cause of action for passing off, there must be a misrepresentation made by a trader in the course of trade to prospective customers of his or ultimate consumers of goods or services supplied by him, which was calculated to injure the business or goodwill of another trader and which caused actual damage to a business or goodwill by whom the action is brought. The third element is damage to goodwill. In the same case, Sid Chuan Seng against T Yi Jia, it was held that in an action for passing off, the damage is an essential element of the tort and it is necessary for the plaintiff to establish that he had suffered real damage. Therefore, by applying to our case, the rightful owner to the trademark of McB is to be given to Bobo. Bobo's family runs a household name that is registered as McBurger. He knows that Malaysians or the public recognize his food chain as McB. There is name established in his food chain. Hence, McB, which was operated by Mr. and Mrs. Bobby Seal, could cause confusion to the public. This is because even though that trademark was not registered under Bobo's, it is a common household name that is used in Malaysia. Continuation use of the name could cause him to lose his customers. In conclusion, McB Seal Incorporative should not use that trademark since Bobo can prove all the three elements established above.